Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation. We will be taking up some of the important articles from the Hindu, the Indian Express, Deccan Herald, and we will also come up with some of the practice questions, and that happens to be the uniqueness of our initiative under the daily news analysis. So what are you waiting for? Hit the like button, subscribe to our YouTube channel, and also share it with your fellow aspirants as well. Let's get started and look into the first practice question and the first article for the day. The first practice question: which of the following statements are correct with respect to cess? It can be levied on both direct and indirect taxes. While the tax proceeds are shared with the states and the union territories according to the guidelines by the Finance Commission, the cess proceeds need not be shared with them. If the amount is unspent for a particular cess collection in any year, it can be used for any other purpose. Which of the statements are correct? Since it is asking for the correct statement, the answer to this is 1 and 2 only. Why have we taken this practice question? Because this article on the Hindu makes a reference to cess as well as surcharge, which is why we have taken this practice question. Let us try and understand what is this concept of cess. We know for the fact that the government of India as well as respective states would be able to impose taxes. In addition to the taxes that has been laid, they can also impose cesses as well. What is tax? What is cess? Cess is nothing but tax on tax. A cess is for a specific purpose. Let's say for example, we have the education cess, or for example, let's say the Swachh Bharat cess. What happens in this case? For example, if the government of India or the respective states are imposing a certain taxes which is called as cess on a particular program, for example the education cess or for example the Swachh Bharat cess, in that particular case the amount that is derived can be used only for that particular purpose, which means to say the government of India or the respective states, let's say it is collecting education cess. For example, this particular amount will be used for upbringing the government schools in the remote corners of the country. This is one such agenda. So the purpose of coming up and imposing a cess is to collect the money for coming up with the government schools in the remote corners of the country. Can this money be diverted for anything else? Let's say for example for the green fund, or for example infrastructure, or for example any other purpose? No. Why? Because the idea or the intent or the agenda or the objective of the very premise of the cess is to ensure that the taxes are imposed primarily for that purpose alone and not for anything else. So the cess being a tax on tax is for a dedicated purpose. It is only for that purpose. It is only concentrating on what is the agenda and the objective for which the cess is imposed. It cannot be diverted for any other activity whatsoever. So this cess can be levied on both direct and the indirect taxes. What is a direct tax? A direct tax is when, let's say for example, I am working in a company, or I am working for the government of India or for the government of respective states. When I am imposed with direct tax, a certain percentage of the money is directly deducted from my salary. So in direct taxes, a salaried person, his employment opportunity is giving him a salary. So direct deduction from his salary is the direct taxes. What is indirect taxes? Let's say for example, there is a tablet, or let's say for example, you buy any of the products. For that, what you pay is certain taxes. So indirect taxes will have to be borne by everyone, but direct taxes will be borne by those people who will be paying the salaries. So it is applicable for both direct as well as the indirect taxes. So the first statement is right. When you look into the second statement, while the tax proceeds are shared with the states and the union territories according to the guidelines by the Finance Commission, the cess proceeds need not be shared with them. What do we understand by this? Let's say for example, the government of India, let's say it collects about 100 rupees by imposing the taxes. We have the Financial Commission which ultimately goes on to say that about 42% will have to be given to the state governments, and the rest 58% that is left out will be given to the central government. Out of this 42%, what we have is called as the vertical devolution, and then what we also have is the horizontal devolution. What is this vertical devolution? Vertical devolution basically happens between the central government and the state government. What is the horizontal devolution? Horizontal devolution basically is about different states. So in different states, let's say for example Maharashtra, or for example Karnataka, or for example Tamil Nadu, what is out of 42%, what percentage will go to each of the state is the horizontal one. Then when we speak about this 42%, what happens? 42% is given to the state governments, 58% is kept for the central government. That is what happens with respect to Finance Commission recommendation. Now a cess is imposed by the government of India, let's say education cess or Swachh Bharat Abhiyan cess. So should it also be shared with the state governments? No, not at all. So when it comes to the taxes that have been collected, out of let's say we have 100 crores, 42 crores will be given for the state government, the rest 58 crores will be kept by the central government. That is the tax distribution according to the Finance Commission norms. But what if there is a cess that is collected? Should they have to give it to the state governments? Not at all. They don't have to go with the state governments. They don't have to contribute to the state government funds. They don't have to give it to the state governments. This is also becoming a sort of dispute between the central governments and state governments. Why? Because state governments allege that you collect the taxes, why go for the cess, why go for the surcharge? You collect the cess and ultimately you're making use of it. You're not giving it anything to the state government. So the state governments also feel that these cesses that are collected at times is also violating the federal principle as well. Why? Because if it is the taxes, it will go to the consolidated fund of India. The Finance Commission will be appointed. They will ensure that there is division of this money between the central and the state government. Ultimately it is the repository that is there, and then they will ultimately decide how much of this money should be divided between the central and the state government. But if it is cesses, it is not even coming to the state government. That happens to be also the friction point between the central and the state government. So should the central government share all these cesses with the state governments? Not at all. They don't have to do it at all. That happens to be the second statement, and it is the right statement. The third statement reads, if the amount is unspent from a particular cess collection in any year, it can be used for any other purpose? No, not at all. As I told you in the start, if it is being made use for a particular entity and an objective and an agenda, it has to stick only for that agenda. Even if they are not able to spend within financial year, what would happen? It will be continuing and they should be used only for that specific purpose. So the point is, you are collecting a cess for education, use it for education and not for infrastructural development. So the first and the second statement are right, but the third statement is wrong, which is why the answer to this would be 1 and 2 only. Now let's look into the next practice question. With reference to the Deputy Chief Ministers in India, which of the following statements are correct? Deputy Chief Minister post is a constitutional post. The official files that are meant for CM are routed through the Deputy Chief Minister. Which of the statements are correct? The answer to this is none. Why? That is because both the statements that are given here are wrong. The first statement says Deputy Chief Minister post is a constitutional post. Is it a constitutional post? No. What is a constitutional position? A constitutional post or a position is one where that position or the authority or an institution is mentioned in the Constitution of India. The Chief Minister is mentioned in the Constitution of India. The Governor is mentioned in the Constitution of India. The ministers are mentioned under the Constitution of India. But is the post of Deputy Chief Minister mentioned in the Constitution of India? No, not at all. So Deputy Chief Minister post is not a constitutional post. If it says it's a constitutional post, no, it is not, because it finds no mention in the Constitution of India. In fact, we have Article 163 of the Indian Constitution, which speaks about the Chief Minister and the Council of Ministers, but does not speak about the Deputy Chief Minister. So the first statement is wrong. When you look into the second statement, the official files that are meant for the Chief Minister are routed through the Deputy Chief Minister. No, not at all. Let's say, for example, there is one file that has to go to the Chief Minister of the state. So should this file first go to the Deputy Chief Minister and then head towards the Chief Minister? No, not at all. The Deputy Chief Minister has no role whatsoever to play. All served to the Chief Minister will directly go to the Chief Minister. The Chief Minister decides on it. If at all a portfolio is allocated to the Chief Minister, he decides on all these files. Nothing of that sort or nothing of this statement is right when it says that all go to the Deputy Chief Minister, then go to the Chief Minister. No, not at all. All these files directly go to the Chief Minister. The Chief Minister decides on it and ultimately a conclusion is drawn. when it comes to such parameters. So the first statement and the second statement are wrong. Why have we taken this practice question? Because this article on the Hindu makes a reference to the Deputy Chief Minister. If we look into Article 163 of the Constitution, there shall be a Council of Ministers with the Chief Minister at the head to aid and advise the governor. Neither Article 163 nor Article 164 says Chief Minister shall be appointed by the governor and other ministers shall be appointed by the governor on the advice of the Chief Minister. It does not make a mention of Deputy Chief Minister. So the first statement is wrong. And we have one of the instances that happen. When you consider the central government and the state government, what happens at the central level? Similar such pattern is present in the state level. Prime Minister, Chief Minister, Council of Ministers, President, and then we have the governor. So what happened in the central government was, whenever you speak about these Deputy Chief Ministers and the Deputy Prime Ministers, why are they generally appointed? Since it is not a constitutional position, why are they appointed? That is because they have equivalent status and stature similar to that of the Prime Minister as well as the Chief Minister. Let me take you back to the period of Jawaharlal Nehru and Vallabhbhai Patel. Jawaharlal Nehru and Vallabhbhai Patel ji, both were eminent leaders, both were great leaders. They have contributed great things for our country. So if at all Jawaharlal Nehru was made the Prime Minister, an equivalent position should also be given to Vallabhbhai Patel because the contributions are equivalent as well. So in this particular backdrop, you create the Prime Minister, but then you also have the Deputy Prime Minister, and at the same time, whenever you speak about the Chief Ministers as well, you will have the Chief Minister, you will also have the Deputy Chief Ministers. These Deputy Chief Ministers will be equivalent in stature. How many Deputy Chief Ministers can be appointed? Is it prescribed? No, not at all. There have been instances where there have been one Deputy Chief Minister, like for in the state of Karnataka right now, we have D.K. Shivakumar sir, who happens to be the Deputy Chief Minister. Then in the state of Andhra Pradesh, there were once 4 Deputy Chief Minister. So is there a prescribed path for it? No, not at all. So it can be more than one Deputy Chief Minister. There can be one Deputy Chief Minister whosoever has equivalent stature that of the Chief Minister, that person will be made as the Deputy Chief Minister. That's the part. And whenever we speak about one of the instances that happened during the VP Singh government, the VP Singh becomes the Prime Minister. Then oath ceremony was taking place. We have the President who was giving the oath ceremony of secrecy as well as promise of sovereignty. During that particular period, there is President who is reciting the statements which ultimately the ministers and the prime ministers will have to say. So when you look at that incident that happened, we have the President who was going on to say that I would be appointed as the minister. But then Devilal ji went on to re-emphasize for the fact that Upapradhana Mantri, just to make that moment lighter, he continues to exercise that right and allows Devilal ji to exercise his right as a Deputy Prime Minister. So this entire exercise, that his oath taking ceremony mentioned it as Deputy Prime Minister, was unconstitutional. Why? Because it goes to the Supreme Court of India. It questions this very oath ceremony. Why? Because there is only Minister, Mantri, and it is not Prime Minister or Deputy Prime Minister. So it is in this particular backdrop, they go to the Supreme Court of India because the oath taking ceremony, he mentions that he is the Deputy Prime Minister. When there is no such constitutional position or the authority that is recognized by the Constitution, how can you take the oath in that name? Was the question that was being asked. And ultimately, the Supreme Court said that there are two parts here. One is with respect to what is called as the descriptive part, then what is called as the substantive part. And this particular judgment was in K.M. Sharma versus Devi Lal and others. What did the Supreme Court say? The Supreme Court says there is descriptive part. What is this descriptive part? For the sake of it. So we have the minister. So the Deputy Chief Minister or the Deputy Prime Minister will hold a rank equivalent to that of a cabinet, which means to say they do not have any extra constitutional powers per se, but they are equivalent to the cabinet or the other ministers as well. Just that it is descriptive. If at all they are taking an oath or the oath of secrecy or sovereignty, in that particular case, this is a descriptive part. It does not re-emphasize anything else because that position is equivalent to a cabinet, that position is equivalent to the Council of Ministers. There is no other extra role or the constitutional proprietaries that are involved to this person. And at the same time, there is substantive part. What is the substantive part? The substantive part is that he happens to be a minister equivalent to the Council of Ministers. So if at all he is taking a oath taking ceremony as a Upapradhana Mantri or Upa Mukhya Mantri, whatsoever that is, it is a descriptive part that word or that iteration is just descriptive in nature, but the real meaning, the substantive part is about he becoming what is called as the minister. So there is no legal bar as to how many deputy chief ministers can be appointed. It is not a constitutional position per se, and he does not play any role if at all a file is being moved from one of the departments directly to the chief minister. So the deputy chief minister has no role whatsoever, and it is on the basis of the recommendation of the chief minister that a deputy chief minister is appointed. So he decides who will be the deputy chief minister. It is he who makes the recommendation to the governor. The governor then appoints the ministers. He can be removed, he can be added, so on and so forth. That can be done. So in this particular article it says that there is demand for 3 more deputy CM resurfaces, says this article. Now let's look into the next article. This article says 5 of 6 accused in parliament breach case give not to undergo polygraph test. Let us try and understand what is this article in greater detail. We have something called as the deception detection test. What is this deception detection test? What is deception? Deception is an intentional form of lying. So let's say there is a question that you encounter from the investigating authorities. Did you go there to that particular place and did you commit the murder? Is a question, and there will be obviously rise of stakes, and there will obviously be rise of pitch as well, and it can also be leading to a torture if at all it is a heinous offense. So what do these people who committed the crime do? Do they accept the crime? No, not at all. And in that particular backdrop, these deception detection tests basically are 3 forms. One is what is called as polygraph. Second is what is narco analysis. Third happens to be brain mapping. So a person is trying to deceive the investigating agencies. So he is committing a blunder, he is committing lies, and is saying wrong facts, which obviously the investigating agencies will have to rediscover through their investigation. There are 2 ways that they can employ. One is the hard and fast rule, which is about torture. There are uncannily manners that can be employed. There can be treatments which is against the human rights. So they cannot employ these things. They may employ, that is a different story, but they are not supposed to employ such hard and fast rules. So what is the alternative to that? In order to prevent this 3rd degree treatment as well as tortures that have been put up on these individuals, an alternative to that is the deception detection test. So he is lying, he is deceiving the investigation officers. So let's come up with a scientific tool, and that scientific tool that exists is what is called as polygraph test. That scientific tool that we have is called as narco analysis. That scientific tool that we have is called as brain mapping. So in this article, it speaks about one alternative in the form of polygraph test. In polygraph test, which we will be discussing right now, there is another process called as narco analysis, where a particular drug or an injection will be ingested into that particular person. Which is this drug? It starts with sodium. What is this drug all about? Please put it on the comment section. That is what narco analysis is. But let's stick to the polygraph test. What happens in the polygraph test? Let's say, for example, I am the person who is undergoing a polygraph test. There will be electrodes that will be stick around my body. As you can see from the image, there will be one here onto my arms, then to my chest, then there will be other electrodes that will be stuck as well. So whenever this particular, then it will be connected to a laptop. So what would happen? There will be these electrodes, there will be other heartbeat ratios, then there will be sensors that will be sensing you. What is the general presumption? Let's say if I'm talking to you, if it is truth, something that you know for the fact, it's a fact, you know for the fact that it's truth, you cannot lie there. So whenever you have a truth that you are speaking, the polygraph test or these rays that you have and these numbers that you see, actually these frequencies that are present will be normal. But if at all you are lying, what would happen in that particular situation? There would be changes in the responses. So whenever you have to lie, it just doesn't flow normally. What would you do? You start thinking about it, you start applying your mind about it. Let's say if I am speaking in this particular tempo, there is a way in which I am speaking, right? So there is truth that is involved. If at all I have to lie, I'll say I am the greatest advocate that is ever born in India. So I will also say that I charge so and so when it comes to my legal profession. So I'm lying somewhere. So I have a particular viewpoint which I'm not trying to say, but I'm creating a story. So if at all I'm creating a story, that is when the polygraph test will catch. So what are the measures? One, the body movements, the breathing, then we have breathing of the chest, perspiration, then the blood pressure, pulse, so on and so forth. So the sensors measure body changes, then the blood pressure cuff records the pulse as well as the blood pressure, then the rubber tubes placed over the chest and abdomen record the breathing, two metal plates attached to the fingers record the sweating. So if at all a person starts sweating profusely, or the rubber, you start breathing, you start gasping for air, this particularly means that there is a benchmark or a number that is given to each of these tests. For example, a blood pressure cuff, there has to be a normalcy. For example, if you go for your thyroid test or for your blood sample test, sugar glucose test, there will be a range that will be given to you. If it is within this particular range, it is normal. If it is way beyond that or it is less than that, it means it is not normal. So similarly, there will be a number that will be given, what is normal, what is abnormal, what is light, so on and so forth, and on the basis of which they will come to a conclusion. So a polygraph test is based on the assumption that the physiological responses triggered when a person is lying are different from what they would otherwise. Instruments like cardio cuff, sensitive electrodes are attached to the person, and variables such as blood pressure, pulse, etc. are measured. A numerical value is assigned to each response to conclude whether the person is telling the truth or he is deceiving or he is uncertain. So on the basis of which they will be able to come to a conclusion. Now the point is, we have to look into two parameters. One is the constitutional position, then we have to look at Supreme Court judgments, we will look at arguments in favor of it, we will look at arguments against it. First is the constitutional position. What happens when it comes to the polygraph test? The polygraph test, let's say for example I am undergoing a polygraph test, so there will be all these electrodes that will be put up on me and everything else. Look at Article 20 of 3. Self-incrimination. What is self-incrimination? Self-incrimination is, I don't have to necessarily give information to the police officers or to the investigating agencies about my own self. Let's say I have committed a heinous offense. Let's say I have slapped some person. I have committed a heinous offense. There is grievous hurt that I have caused to another person. So this is where grievous application comes into the picture. Grievous hurt comes into the picture of IPC. So the police officers come and ask me, where is that you have put up this particular place? I have taken a stick, I have caned another person. So I have taken the stick and I have placed it somewhere. So they ask me a question, where have you placed this cane? So should I be answering them? I can keep silent, because that is what self-incrimination is. I don't have to self-incriminate me. I don't have to give evidence against me. So I have been given this constitutional position under 20 of the, that I don't have to self-incriminate me. So if at all a polygraph test is being conducted, I am again self-incriminating me, which is against this very provision. Then at the same time, we have Article 21 of the Indian Constitution. What does it speak about? Right to privacy. If at all a polygraph test is put up, I will not be able to keep up the important facts. This is violation of Article 21, right to privacy. So these are the constitutional aspects. Now when we look at the Supreme Court judgments, what does the Supreme Court say? We have Selvi and others for the state of Karnataka and another, where the Supreme Court said that yes, you would be able to take up the polygraph test, because we have the third degree treatments that are employed by the investigating agencies. As an alternative to it, you can start making use of this deception detection test. But in the deception detection test, what is the important factor? That person, whosoever is going through it, should voluntarily accept it. So there should be an advocate. The advocate and the investigating agency should say the ramifications of this particular test. They should also say what could be the likely consequences, and ultimately, if at all the person accepts voluntarily, not by force, not by coercion, not by any interference or by any action, but voluntarily he accepts that I am ready to go to the polygraph test, I am ready to accept the narco analysis. In that case, if it is voluntarily done, then in that case you would be able to take up the polygraph test. In the instant case, you have the persons, 5 persons who are accepted for the polygraph test, and that happens to be on a voluntary basis. So there has to be consent that is be taken. They should know the likely consequences of it, and ultimately the consensus has to be drawn. That is the first one. The second point is that whenever this consent is drawn, what should happen? This will not be directly taken up as the acceptance. This means that during this entire process, let's say I have hit a person with a cane or with a stick. So I confess I am in a deeper sleep. Let's say I am being ingested with narco analysis. I am not in my senses. So I am in deep sleep. So what do? There are questions like this. The police officers ask me, where is that stick? So I say that stick is in my home, in my room, under the cart. So if at all I make a statement like that, because I'm in deep sleep, because I'm given the drug as well. So I'm not in census. So what do the police officers do? They immediately enter my home. They go up to my room, under my cot, under my bed cot, they find the stick that is present. So this can act as a corroborative evidence, and ultimately they can prove. So the statement that I'm making may not be acceptable, may not be acceptable. It is acceptable or may not be acceptable. But if at all I am making a statement, and after the investigation and after justification they prove that there was that particular tool or ever, then in that case it is accepted to the court of law. Then we have another judgment, Nandini Satpathy versus PLD. No one can forcibly extract statements from the accused who has the right to keep silent during the course of interrogation. By the administration of these tests, forcible intrusion into one's mind is being restored to, thereby nullifying the validity and legitimacy of the right to silence. These are the landmark judgments delivered by the Supreme Court of India for the deception detection test, and polygraph test happens to be one of the deception detection test. What are the advantages? Should polygraph test or deception detection test be done? Yes, it should be done. Why? That is because it's an alternative to torture. There will be human right violations if at all third degree treatments are used, and then we've also been seeing that there have been couple of grave offences that have been committed, murders, rapes, so on and so forth. So in order to provide victim the justice, this process has to be taken up as well. And at the same time, whenever a polygraph test is done, this will ultimately ensure that justice is delivered, and people's trust in the justice delivery system will also be reposed. What is about polygraph test? What are the disadvantages or why it should not be used? It is not 100% accurate, because many people say that it is 85 to 95% accuracy rate, but still that 10% or 15% there is no accuracy. So it is in this particular backdrop, it cannot be tested. So if we speak about narco analysis, there is a drug that is given to a person. So if the drug percentage slightly increases, this can also have side effects as well. So these are some of the disadvantages. So this can be very important from your GS paper 2, which is to do with your polity. Now let's look into the next article. This article says the need to examine the examination system. Let me explain this article briefly. All that this article says is we have the education system. What does the education system have? The education system basically has examination pattern. So all that you have is a trimester system, then you also have the semester system, then you also have in some annual systems as well. What happens? A person is made to study for about 3 months, then exams, for about 5 months, then exams, or annually for about 11 months and then exams. So during this entire process, what would happen? A person is asked to memorize things. He is asked to keep things in his memory, and ultimately he has to put this out on the paper. Higher the marks, the idea and the perception is this person is damn brilliant, and the recruiters and other people also start recruiting only those people who've got large or highest number of marks. That is one part of the story. The other part of the story is when you emphasize on the memory, you're not giving impression of application of the mind. So whenever an examination is conducted, it should not be on the basis of rote learning, it should be on the basis of application. So I learn a particular concept, how am I gonna apply this concept to the real-time situation? Let's say for example, you have a code, you learn about C programming, you learn about Java, you learn about .NET, or you learn about microprocessors, so on and so forth. So the theoretical framework, when applied into the practical framework, that's what is the real beauty of education. But instead, all that I'm asked to do is rote learning, and as a result, the teachers also teach in such a way instead of application of the mind. That happens to be the major fundamental problem in the Indian education system. That apart, when it comes to the education system, it is not just about the classrooms and all that. We are living more in the fourth industrial revolution, where there is artificial intelligence, where we are making use of the machine learning and so on and so forth. At this particular moment, why do you need memory? Why do you need memory? Because you have to apply one part, but this has to be in an applied sciences. Applied sciences as in when I am able to take up a particular concept, apply it to the sciences, and then get a solution to the existing problem. That is the need of the hour. So the author goes on to say, instead of re-emphasizing on the fact that you have to keep rote learning, teach them the module of applying a certain concept so that they are able to derive a solution to the existing problem. Added to that, apart from the classroom programs that we have, they have to directly speak to the industries, they have to speak to the companies to basically ensure that they are applying their mind for the existing problems. Only when they do so, they would be able to ultimately correct it, is what is this article all about. All that I want you to do is just skim through this article. It's a basic common sense article. So where you have to say, bring about a curriculum change, bring about an institutional change, bring about, give them more decentralized system, give them autonomous power, come up with common guidelines for all industries, but at the same time give them more leverage to discuss and come up with innovation in the education system. The pedagogy has to change over a period of time. So it's a general article. Just skim through this article, but the general perception and the overall objective criterion is we have discussed it, but if you skim through the article, you will understand the author is trying to emphasize these very facts. Now let's look into the next article. This article says antimicrobial resistance drug war. What is this article speaking about? The article here is speaking about the antimicrobial resistance. What is this antimicrobial resistance? Let's say, for example, you are suffering from one of the diseases, or let's say, for example, health disorders. So at that particular moment, let's say you're suffering from a bacterial disease. So what do the doctors do? They give you antibiotics. So the minute they give you antibiotics, obviously what will happen? This will reduce the pain and it will cure whatever issues that you are facing from. But over a period of time, there has been excessive use of these antibiotics. What is the major issue? Even before they are able to assess what the issue is, even before they want to identify which is the bacteria, they have been given excessive antibiotics as well. So what should ideally happen? You should identify what that issue is, then identify what is the root cause of it, and then give the antibiotics. To find out what is the bacteria, they have been giving antibiotics. For every other things, they have been giving antibiotics as well, and ultimately this is creating what is called as the antimicrobial resistance. What is antimicrobial resistance? Apply the theory of survival of the fittest to the bacteria and other viruses. So because there are these drugs that are being administered to the people, this will obviously eliminate the bacteria. So bacteria are also becoming smarter day by day as well. So when they become smarter, when these drugs do not have any application on the bacteria, they have become resistant to such medicines, and these medicines are no more useful for those who want to eliminate a particular kind of bacteria. That will what will lead to antimicrobial resistance. So there is a resistance by these microbials, that is by the bacteria and the viruses. This medicine is no more applicable. Why? Because it is not even helping reduce the pain or overcome that particular issue, which will lead to antimicrobial resistance. So when excessive antibiotics is being given to a patient where there is no need, even in that case if it is administered, this will lead to antimicrobial resistance. So this article says that there is excessive use of these antibiotics, and as a result there is antimicrobial resistance, for which the authors have given the numbers. Kindly look through it. These are for the statistical evidences. So in case there is a question that is being asked, you have to speak about such terms and conditions. Now let's look into the next article. This article says Cabinet gives nod to Prithvi program. What is this Prithvi program? The Union Cabinet has cleared 4,797 crore called as Prithvi, which is Earth, that is expected to subsume 5 existing schemes of the Ministry of Earth Sciences. So the Prithvi program is a program initiated by the central government, which is a ministry that is taking care of it, Ministry of Earth Sciences. These programs are to improve and increase long-term observations of the atmosphere, atmospheric changes. Then what we have is the ocean. Then we have is the gasosphere, cryosphere and solid earth, to track changes in the planet, develop models to understand and predict the weather, ocean and climate hazards, understand the signs of climate change as well, explore polar and high seas regions of the earth to discover new phenomena and also resources, develop technology for exploration and sustainable harnessing of the oceanic resources, and ultimately translate the knowledge and insights from the earth system into the environmental and economic benefit. So the process is to ensure that all these aspects are sustained and maintained in the Prithvi program, where they are subsuming about 5 different programs. So this is important from your GS paper 3, environment and ecology. So this is what we have to understand, and it is your advocate Ajay Narayan who is signing off. See you tomorrow same time, and we will be coming up with more interesting facts for your KPSC examination perspective. If you're liking these initiatives, like the button, hit the subscribe button, and also share it with your fellow aspirants as well. Thank you for watching. All the best.